This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So Richard Leibowitz has lost yet another case, and this time it's on fair use grounds. That makes copyright attorney Leonard French very happy. Let's take a look. This is Rebecca Faye Walsh suing Townsquare Media, again in the Southern District of New York. I think you'll notice that Leibowitz likes to stay in the Southern District of New York these days because he's being sanctioned everywhere else as well. And that's Southern District is where he lives, so that's going to be a lot easier for him to get sanctioned in. Plaintiff Rebecca Faye Walsh brings this action against Townsquare Media, asserting a claim of copyright infringement in connection with defendant's unlicensed publication in an online article of a copyrighted photograph taken by plaintiff. Before me is defendant's motion for judgment on the pleadings. Because defendant's publication of the photograph constituted fair use, defendant's motion for judgment on the pleadings is granted. Plaintiff is a Brooklyn-based professional photographer who licenses her photographs to online and print media for a fee. Defendant is a Delaware incorporated business that owns and operates an online website called the XXL Mag, located at xxlmag.com. On September 5th, 2018, plaintiff photographed rapper and celebrity Cardi B at a Tom Ford fashion show in New York City. Around the time of the fashion show, she captured numerous photographs of Cardi B and then made them available for license through Getty Images, a stock photography agency. Among these photographs is the one at issue in this action, reproduced below in resized but uncropped form. Plaintiff has a copyright to the photograph, which is registered with the United States Copyright Office. On September 10th, 2018, Townsquare ran an article on XXL Mag entitled Cardi B Partners with Tom Ford for New Lipstick Shade, available at the following URL. The text reads, Cardi B is having a busy 2018 New York Fashion Week. After allegedly getting into a fight with Nicki Minaj, the Invasion of Privacy rapper is now getting her own shade of lipstick from Tom Ford. The Tom Ford beauty brand broke the news on Sunday, September 9th, posting an image of the blue bold shade of Cardi's name on Instagram. Meet Cardi, TF Boys and Girls, TF Lip, T-Flip, Tom Ford, yeah, TF Lip, I guess. Tom Ford Beauty. The caption of the post reads, Cardi also celebrated the news on Instagram, reposting the Tom Ford post and adding, thank you so much, Tom Ford and Tom Ford Beauty. So excited for this and what's to come. Just the latest shade in Tom Ford's Lips and Boys collection. The new Cardi shade follows the brand's trend of naming lipsticks after other celebrities such as Julianne Moore, Dakota Johnson, and Naomi Campbell. There's no word yet when the lipstick inspired by Cardi will be released. As expected, the decision to name a lipstick after Cardi following the New York Fashion Week incident has led to a heated debate and the original Instagram post. While some fans were excited about the upcoming product, others felt that Cardi doesn't deserve to have lipstick named after her. But Cardi doesn't seem bothered by that. In another Instagram post, the rapper claimed the upcoming lipstick has already sold out, adding, sorry. In footage from the fight, the Be Careful rapper can be seen throwing a shoe in the direction of someone, although it's hard to make out if it's actually Minaj. Cardi can also be heard yelling at someone for talking about her daughter, Culture. Write some shit about my daughter again, Cardi says. Classy people. While it was reported that Barty's fight was with the Queen artist, Cardi reportedly ended up fighting former Love and Hip Hop New York star Ra Ali. Beneath the last sentence of the article, XXL Mag embedded the 3 Instagram posts that were described in the article. Plaintiff does not allege that the post was embedded, only alleging that defendant expropriated the photograph and displayed it in the article. However, defendant asserts that the post was embedded, and plaintiff does not dispute this allegation. Moreover, in the current version of the article, the 2 Instagram posts that remain displayed link directly to Instagram when clicked on, indicating that they have been embedded. And they provide the link here. The first post by account Tom Ford Beauty announced the lipstick collaboration. The second post from Cardi B's account reproduced the post by Tom Ford Beauty in a screenshot and thanked Tom Ford and Tom Ford Beauty. The third post from Cardi B was a composite image consisting of an image of the Tom Ford lipstick on the left, the photograph on the right, and the heading, Cardi B's Tom Ford lipstick has already sold out. Above the composite image was Cardi B's username, her follower count, and a link entitled View Profile. So, an Instagram post. Below the composite image was the View More on Instagram links, etc. An Instagram post. That's what they look like. If you haven't looked at an Instagram post, you might be living under a rock. After plaintiff filed this lawsuit, defendant removed the post from the article. Plaintiff commenced this action by filing a complaint May 28, 2019. the complaint was administratively rejected and had to be refiled. So this is a different kind of motion to dismiss than we usually see. Rule 12C as opposed to 12B6. Rule 12C provides that after the pleadings are closed, so pleadings means a complaint and then an answer. There's other pleadings, but for our purposes, that's all we care about. So a complaint makes the actionable statements, you did this to me. And the answer says, yes, I did, or no, I didn't. And maybe some other defenses and things like that. So Rule 12C provides that after the pleadings are closed, but early enough not to delay trial, a party may move for judgment on those pleadings. In deciding a motion for judgment on the pleadings, a district court must employ the same standard as a motion to dismiss, accepting all factual allegations in the non-moving party's pleading as true, and drawing all reasonable inferences in the non-moving party's favor. That just means that when the court is going to look at these two documents aren't going to answer every question. So we're going to answer any questions hypothetically. And we're going to say, okay, so since Cardi B is the non-moving party and Town Hall or Town Square is the moving party, we're going to use this hypothetical standard. And anytime we come upon an ambiguity or vagary or question, we're going to answer it in Cardi B's favor. And if even after answering it in Cardi B's favor, the case still works out in favor of the defendant, in favor of the moving party, the person asking for judgment on the pleadings, then they deserve judgment on the pleadings. If even after giving them the benefit of the doubt, Cardi B the benefit of the doubt, Rebecca Faye Walsh, we're giving the photographer the benefit of the doubt. Even after giving the benefit of the doubt, the other person is still correct, then yeah, we can end the case here. That's what the policy is behind that. Therefore, to survive this motion, a complaint must contain sufficient factual matter after being accepted as true that states a claim to relief that is plausible on its face, and therefore needs to go further in the pretrial and trial process. A party is entitled to judgment on the pleadings only if it has established that no material issue of fact remains to be resolved and that it is entitled to judgment as a matter of law. Man, that sounds an awful lot like the summary judgment standard. The only difference really between the two is that this is before discovery and summary judgment would be after discovery. So judgment on the pleadings is after the pleading stage, which is the initial stage of a lawsuit. Summary judgment is after discovery and just before trial. There are other places to use summary judgment. Those are the main ones. On a Rule 12C motion, the court considers the complaint, the answer, and any written documents attached to them, and any matter of which the court can take judicial notice for the factual background of the case. That's known as the scope of review. So this is a really complicated topic. So this one's just for the law students out there. When you start to think about scope and standard of review, up here, this was the standard of review. Accepting all factual allegations in the non-moving party's favor, the motion to dismiss standard of review. This then down here, what evidence you may consider is the scope of review, or what decisions you may consider is what the scope, what is being considered and what you may use to consider them is the scope of the review. The complaint is deemed to include any written instrument attached to it as an exhibit, materials incorporated in it by reference, and documents that, although not incorporated, are integral to the complaint. Discussion. The Copyright Act grants a copyright owner the exclusive rights to authorize the reproduction, distribution, and preparation of derivatives of the owner's work, 17 U.S.C. Section 106. These rights, however, are in inevitable tension with the ability of authors, artists, and the rest of us to express them or ourselves by reference to the works of others. The doctrine of fair use mediates between these two sets of interests and infuses copyright law with the necessary breathing space. Under this doctrine, a defendant who otherwise would have violated one or more of these exclusive rights may avoid liability if it can establish that it made fair use of the copyrighted material. To evaluate whether a particular use qualifies as fair use, a court must engage in an open-ended and context-sensitive inquiry that focuses on 4 non-exclusive factors set forth in the Copyright Act. 1. The purpose and character of the use. 2. The nature of the work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the secondary use on the potential market for or value of the original copyrighted work. The Copyright Act also provides examples of purposes for copying that would constitute fair use: criticism, comment, news reporting, teaching, scholarship, and research. These examples, however, are illustrative and not limitative, and the court's task is not to be simplified with bright-line rules. Fair use is an affirmative defense, and so a defendant accused of copyright infringement bears the burden of showing that its use of a work was fair. The determination of fair use is typically a mixed question of fact and law. However, it may be adjudicated on a Rule 12c motion where the facts necessary to establish the defense are evident on the face of the complaint. Accordingly, numerous courts in this district have resolved the issue of fair use on a motion for judgment on the pleadings by conducting a side-by-side comparison of the works at issue. Plaintiff asserts that defendant infringed her copyright by reproducing the photograph on its website without licensing it. Defendant does not dispute for purposes of this motion that it reproduced the photograph, but contends that its use of the photograph was fair. To assess whether defendant's reproduction of the photograph was a fair use, I consider each of the four factors in turn. Now, I also would have inserted an implied or expressed license counterclaim or affirmative defense in my defenses of this defendant, as Instagram is going to have its own contract with the photographer, and so posting a embedded version of the Instagram post would be within your license with Instagram and within Instagram's license with the photographer, and so you have an implied license. We'll see if the judge gets to that. Maybe the judge says that the license makes it a fair use. I don't know. Let's see. The first statutory factor, the heart of the fair use inquiry in this circuit, calls on the court to examine the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. The focus of this factor is whether the use merely supersedes the objects of the original creation, or instead adds something new, with a further purpose or different character altering the first, with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. A transformative use is one that communicates something new and different from the original or expands its utility, thus serving copyright's overall objective of contributing to public knowledge. The critical inquiry is whether the new work uses the copyrighted material itself for a purpose or imbues it with a different character from that for which it was created. While the Copyright Act suggests that use of a copyrighted work for news reporting purposes is likely to constitute fair use, a news reporting purpose by no means guarantees a finding of fair use. After all, the promise of copyright would be an empty one if it could be avoided merely by dubbing the infringement a fair use news report. Thus, courts have held that it is not a fair use to use an image solely to present the content of that image in a commercial capacity, or to otherwise use it for the precise reason it was created. For example, it is not fair use to republish a photograph of a celebrity or a public figure intended to generically accompany an article about that person, or to describe the event depicted in the photograph. Such uses merely supersede the objects of the original creation. However, use of a copyrighted photograph may be appropriate where the copyrighted work is itself the subject of the story, transforming the function of the work in this new context. For instance, a news report about a video that has gone viral on the internet might fairly display a screenshot or clip from that video to illustrate what all the fuss is about. Similarly, a depiction of a controversial photograph might fairly accompany a work of commentary or criticism about the artistic merit or appropriateness of the photograph. Courts have also found fair use cases in which a website published a screenshot of an article from another publication that contained a copyrighted photograph alongside criticism of the article. Applying these principles and drawing all inferences in plaintiff's favor, this factor favors defendant because the article uses the photograph for an entirely different purpose than originally intended. The photograph was taken to depict Cardi B at Tom Ford's fashion show. Paparazzi photographs are designed to document the comings and goings of celebrities, illustrate their fashion and lifestyle choices, and accompany gossip and news articles about their lives. However, as is apparent on the face of the article, defendant did not publish the photograph simply to present its content. It did not use the photograph as a generic image of Cardi B to accompany an article about Cardi B, or as an image of her at Tom Ford's fashion show alongside an article about the fashion show. Rather, the defendant published the post, which incidentally contained the photograph because the post, or put differently, the fact that Cardi B had disseminated the post, was the very thing the article was reporting on. So in other words, the article was reporting on how Cardi B had posted the post, or reposted the post. The article begins by juxtaposing the news of the lipstick collaboration with rumors that Cardi B has recently gotten into a fight with Nicki Minaj, another rapper. It goes on to describe the social media post by Tom Ford and Cardi B introducing the collaboration and the ensuing heated debate among fans about that announcement, in light of the rumors about the fight. Then the article presents Cardi B's reaction to that heated debate, her Instagram post reporting that the lipstick has sold out, with the caption, "Sorry." Finally, the article reports additional facts about the rumored fight, then embeds the relevant Instagram posts, one of which happens to include the photograph because the original poster, Cardi B, included it. The article does not mention the photograph, nor does the photograph in and of itself pertain to anything reported on in the article. Thus, defendant's inclusion of the photograph as part of the post was not simply to present the content of the image, Cardi B, or perhaps Cardi B at the Tom Ford fashion show, i.e. the purpose the photograph was created for. Rather, Cardi B's making and dissemination of the post, not the image that was posted, was itself the subject of the story. In other words, defendant published the post in order to provide readers with the original social media interactions reported on by the article, and included the photograph as a necessary part of the post. Indeed, no other image, not even the photograph itself as a standalone image, would have fulfilled the same purpose as embedding the post itself. Merely displaying the post without the photograph would have been nonsensical in appearance, as well as potentially impossible, given that the post is embedded and hyperlinked, rather than inserted as an image. The photograph's function was wholly transformed in its new context, and as a result, the article's publication of the post in no way merely supersedes the original work. Judge Paul Gardeffi's analysis in Ferdman v. CBS Interactive is instructive, although the facts did not mirror the facts here, making the decision distinguishable. In Ferdman, the defendant published an article that stated that images and videos from the set of Spider-Man Homecoming may have steadily emerged. The newest shot comes from the Instagram of Spider-Man actor Tom Holland himself. The article then described the image, which had been posted to Holland's Instagram, repeated Holland's accompanying caption, and inserted the photograph, but not the Instagram post itself below the article. Judge Gardeffi observed that, as in Nunes, the photograph was the story, but ultimately denied defendant's motion for summary judgment because there were no visual differences between the copyrighted photograph and the photograph included in the article, and two, the statement at the beginning of the article that images and videos have steadily emerged suggested that the photograph might merely have been used to announce its existence, which would not be transformative. Judge Gardeffi held that these issues may cause reasonable jurors to disagree about whether the use was transformative, and so the issue could not be resolved as a matter of law and needed to go to a trial before the jury. Here, as in Ferdman, the post was the story, but unlike in Ferdman, defendant embedded the entire Instagram post, still bearing the rest of the elements of the image that Cardi B had posted, the header and the photo of Tom Ford lipstick, along with Cardi B's caption and various Instagram standard links, making clear that the subject of the image was the post, not the photograph. In addition, unlike the article in Ferdman, defendant's article does not even mention the photograph itself, much less report on it specifically. Its focus is on the launch of the Tom Ford lipstick, the ensuing social media controversy, and Cardi B's post. These distinctions foreclose a reasonable juror from finding defendant's use not transformative. The fact that the article did not include any commentary or criticism about the post, unlike the uses in Yang and Clark, does not undermine this conclusion. While courts often find news reporting uses transformative by emphasizing the altered purpose or context of the work as evidenced by surrounding commentary or criticism, commentary or criticism is not required to render a use transformative where the two works have different messages or purposes. Nor does the perhaps trivial nature of the article weigh against defendant. While the ultimate test of fair use is whether the copyright law's goal of promoting the science and useful arts would be better served by allowing the post than by preventing it, the Supreme Court has cautioned courts to be wary of deciding what is and what is not news. Finally, plaintiff argued that defendant is a for-profit publisher that disseminates commercial news content on its website, including advertisements evincing defendant's intent to exploit plaintiff's work. The commercial nature of a use may indeed counsel against a finding of fair use. However, the Second Circuit has recognized that almost all newspapers, books, and magazines are published by commercial enterprises that seek a profit. The Supreme Court has acknowledged that tension and stated that the crux of the profit-nonprofit distinction is not whether the sole motive of the use is monetary gain, but whether the user stands to profit from exploitation of copyrighted material without paying the customary price. That a defendant's use of copyrighted material is for profit bears little weight when that use is highly transformative, but where a defendant's use merely supersedes the objects of the original, the commercial nature becomes more relevant. Here, regardless of whether the defendant profits from page views of the article, its use of the photograph is transformative, outweighing the commercial nature of the use. Accordingly, I find the first factor strongly favors fair use. And then they go on to the other factors, which I'm going to skim through. The nature of the work. The photograph contains both informational and creative elements. It was taken to document its subject, but it displays technical skill and aesthetic judgment. The photograph was previously published by Cardi B on her Instagram, thus pairing the neutrality of the images with the fact of previous publication. The nature of the images tips slightly in favor of fair use here. The portion of the work used, the post included an uncropped, though resized version of the photograph. As a qualitative matter, however, although plaintiff complains that defendant could have used any other image of Cardi B to accompany its article or requested a license, the post is the only image that could have accomplished XXL Mag's journalistic objective of describing a social media story and providing readers with relevant posts. Even the photograph itself on its own would not have been a reasonable substitute. Within its objective, defendant used only as much of the photograph as was already included in Cardi B's post. In other words, no more than what was necessary. Therefore, the third factor favors fair use. The potential market for or value of the original work. Here, because the photograph did not appear on its own but as part of the post alongside text and another image, it is implausible the defendant's use would compete with plaintiff's business or affect the market or value of the work. Also, by embedding it, I mean, they still got all the views and they still got a link back to Instagram. Like, this is the preferred way to share a photograph and not make a copyright infringement of it. I really don't understand why we're not talking about a license, because license should have trumped the fair use in this case. I don't see how there's any copyright infringement for embedding someone's tweet or embedding someone's post if that's supported by the platform. I don't think you need to have any copyright authorization for that. But don't take my advice, or don't take that as advice, because it can't be legal advice. It's not individualized, and I could get in trouble for that. So you got to go do your own research and figure out whether court cases say that you can embed and that's not copyright infringement. But my understanding is that you can embed and that's not copyright infringement. So they say that the fourth factor favors fair use as well. Thus, the four non-exclusive statutory factors weighed together appear to favor fair use. I have found on the face of the complaint the four factors weigh in favor of defendant. Defendant's use was transformative. Its use was reasonable in light of that end. The work was already published. There was no plausible risk to any market for licensing the original work. This is sufficient to establish an affirmative defense of fair use on a motion for judgment on the pleadings, and I conclude that defendant's use of the photograph was fair use as a matter of law. For the foregoing reasons, defendant's motion is granted and this action is dismissed with prejudice. The clerk of court is directed to terminate the motion on document 14 and terminate this case. And that's Vernon S. Broderick, United States District Judge for the Southern District of New York. And so maybe we'll see now. It's going to be the 14th now, so maybe we'll see shortly here. There will be a motion for fees and costs by Town Square Media. Nope, I don't see it yet. So we'll watch out to see if there's another fees and costs motion against Richard Leibowitz and his clients. So we'll see what happens there. So that was remarkable. It turns out that this judge can find fair use in embedding a post. Great, but I still think they had a license. What do you think? Do you think it matters? Do you think you have both? Do you disagree? Do you agree? Are you just happy to see Richard Leibowitz's clients continue to lose cases because he doesn't take the time to properly do his due diligence? It sounds like. I guess I'm not making like a formal accusation, just sort of like referring to all those other accusations. Anyway, let me know what you think in the comments below. So that's our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite community-supported legal news and educational channel here on YouTube and also on Floatplane. Thank you for your monthly support on our various support platforms. Patreon.com/LJFrench, Sponsors.com/law, YouTube memberships, Twitch subscriptions, and Floatplane memberships as well. Thank you in June to the $50 plus supporters: Joe Tyson, Wes Delge, Citizen of the Sovereign, John Steele, Gavin Barnard, Evie, Kyle Mudrock, Spirit Bear, Jan Negre, Michael Pierce, Daniel Perez, Blackleaf, Benjamin Hightoff, Steven, Otta, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shiloh T, Josh Baker, Gregory, Rudolph Bescherer Jr., Christian Hellman, Jay Dixon, Ammonite, Oscar the Prophet, and Hot Grills in Your Area, a new supporter who just popped up yesterday but already paid for June. And thank you to the June $5 plus supporters who are scrolling on the LED panel next to me and will be on the crawl of the videos and the descriptions below. I love you all. I'll see you in the videos that drop. Bye. That was a great kick. I used to play soccer. European football. Probably hurt myself now if I tried. My bad. My bad. Ooh.